I will keep it extremely short and also no faltu ka gyan. We've got a lot of textbooks for it, and it would be just based on the practical experience of some 4,000 pages cross examination spanning over 7 years, 10 to 4 in 2G scam case, and now so many trials in the coal scam every day. Today, we are discussing this Rashomon effect concept and how a defense lawyer makes use of it. Invariably, in all the cases, you have multiple witnesses fielded by the prosecution describing the same event. And that's the fatal mistake a prosecution does. And that's a boon for a defense lawyer. And the defense lawyer, by playing on this concept of Rashomon effect, recognizing the dark side of the human nature, that a witness is going, as said by Supreme Court in Said Akbar judgment, that he has to give an embroidery to the event. Every human being has different perception, his different way of looking at things. So regarding the same event, if there are multiple people, say for example 4, then everyone is going to narrate the event in their own different fashions, and there are bound to be contradictions. And once you read all 4 and you've cross-examined them well, then you can say that all 4 are not singing the chorus. Various places, these multiple people are speaking or playing different notes or codes, and so the prosecution's song is to be rejected. Defending a client is a job much easier than prosecuting a person. A prosecutor has to prove his case beyond reasonable doubt. He has to, by examining the witnesses and exhibiting the documents, brick by brick, create an enclosure, create a wall to cage your client. His wall has to be flawless. And then the defense lawyer comes and he just simply removes one brick out of the wall, creates a doubt, presents an alternate hypothesis, and find flaws. And we all are good at finding flaws. And he will be home, he'll be taking his client home and break the cage created by the prosecution. So, defense of the client being an easy job, I chose to be a defense lawyer. Earlier, it was said that better brains are on the defense side, and we defense lawyers get paid handsomely, and we have swanky offices and an army of interns, juniors, associates, and great infrastructure. But now you do any big case, there will be better brains on the other side. You will face the counsels who, being the best defense counsels of their time, still there are the very prominent defense counsels that are, but they're appearing in a particular case as a special prosecutor. And these specialized agencies like CBI and ED and SFIO will have great prosecutors. In 2G scam, we had from the opposite side none other than Mr. Yuju Lalit, and after his elevation, we had Mr. Anand Grover, and they were very ably assisted by initially by Mr. Singh and then with Mr. Goyal and others. In coal scam, we have Mr. Chima assisted by Tarunam Chima, both great defense counsels, and assisted by one Mr. Singh and Mr. Sharma and Mr. Sanjay, who themselves are a school in their own selves. In Ratulpuri case, I faced Mr. D.P. Singh, who is a great defense counsel. And most aggressive counsel whom I face is one Mr. Nitesh Rana, whom I faced in this Sanjay Singhal Bhushan case. So, even though your job is easy, but you have great opponents these days. And there is one main aspect in which the defense counsel is little difficultly placed, because the prosecutor ke paas maa hai. He has IO with him. Defense counsel may have a lot of things, but the prosecuting counsel has IO. Now this IO is the architect. He has built this castle to cage the client, and he is the one who's going to brief the prosecutor. So he would know that while preparing a cage for the client, for the accused, which witness is deposing on which event, which documents, which witness is going to prove. See, when they file the charge sheet or a criminal complaint in ED cases, SFIO cases, they enclose a list of documents and list of witnesses and their opinion. What is a charge sheet or a complaint which is finally filed after investigation? Is the opinion of the investigating officer based on the evidence. And what is the evidence? Documents or oral? Oral is recorded in the statements. So you will get a list, and with those statements, the documents, you will get the list of documents as well as the documents. But they never point out that which fact they want to prove, with which document, with which witness, that assistance IO will give to the prosecutor. So you have to learn to peep into the PP's briefing when IO is standing next to him in the court, and do your own homework. So you would know that how to defend your client. First of all, look at the charge sheet with the various documents and the witness statements like a prosecutor. See that which are the various events or stroke circumstances or say fact in issue which the prosecutor is going to prove against you, and which witnesses, which oral testimonies is he supporting his case with, and with the help of which documents. So the first exercise that a defense lawyer on getting hold of the charge sheet is to find out the various circumstances on which the prosecution case is based and the various witnesses. So generally, I prefer to advise, or I practice with myself, that the charge sheet is to be broken event-wise. Then prepare a table that this is the event, and this particular thing is being deposited by the witness 1, 2, 3, and the document against is document 1, 2, 3. Then place it on a table so that you know that on a particular event, so you have to break down the charge sheet first, say into 40, 50 points, or in a smaller case, 10 points, 12 points. So you will know. And then there will be also the witnesses who are following the case from cradle to the grave. Like in 2G case, you had one particular witness who had some 161 statements and 164 statements. Even when his examination in chief was recorded, it was running into some 400 pages in the court. Same way you have one in coal scam also. There is one witness which is common in various cases. The coal ministry senior officer, his statement is almost same, and that is running into several pages in each and every case. So you have to categorize these witnesses, and these long witnesses you have to say that he is deposing about event 1, event 2, event 3, event 4. Once you are through with that exercise, then you have to, then when the examination in chief is being recorded, that time you have to make use of section in a sessions trial, section 231, subsection 2 CRPC. And warrant trial, you have to make use of section 242, subsection 3 proviso, wherein you can pray to the court that their examination in chief be recorded, and then I will be cross-examining them one after the another, because you cannot prepare your cross unless and until you know the actual deposition. You rely upon just 161, so you should know their actual deposition in the court of those 3, 4, 5 people, and then you can say that I am going to cross-examine them in one go, one after the other. And there are various Supreme Court judgments also to that effect, that if such an application is moved, and my practical experience is that no judge refuses, as long as you are not coming in the way of recording of their examination in chief. So this concept of Rashomon effect then comes into the play. This term got coined, though long back people have forgotten it was. This concept was there in one Agatha Christie's novel, Five Pigs, in 1942. But in 1950, this became very popular. The movie Rashomon came, Japanese movie, which went on to win various awards. And then, if you see the later movies, though there are a lot of such movies, I can name few. One is Vantage Point, one is Courage Under Fire, one is the recent one is Gone Girl, and our Indian answer is I would say Ittifaq or Talwar, which is in fact based on a criminal trial where you can see the various servants and drivers and the households narrating the same event in their own way. So the various witnesses are narrating the same set of event in their own special way. The prosecution has to show that their witnesses are consistent, there is no ambiguity, one side is bound by his own witnesses, so they have to show that their witnesses are not contradicting each other, they are singing in chorus, but because of the human nature, that is never possible. See, this truth is not defined in the Evidence Act. Evidence Act uses the word proved. Proved is when the court believes a thing to be true, or a man of ordinary prudence would believe it to be true. So, Mr. Defense Counsel, you have to create a doubt. You have to belie that belief with the help of your cross-examination. This belief can be belied if you study those various witnesses. First of all, you group those witnesses, then you study those witnesses to see that even in 161, where there is some slight contradiction, and then in cross-examination, the technique can also be to ask invariably the same set of questions from every witness so that they are going to contradict each other. So even if they are not contradicting themselves, in 161, they have not contradicted much, in examination in chief. So you have to lay that bait, and you have cross-examined one. He has narrated various sequence of events. Then you ask the same set of questions from two and lead him into contradict the previous witness. Now suppose after an year, you watch this video, after an year, I ask four of you that for how long was the video, what shirt was I wearing, when you were watching the video, uh, you were home or you were in office or were you traveling. So every person is going to give a different kind of an answer. In this Japanese movie, there is a samurai who is murdered, and various witnesses, they come and they give their own varnished account. And then for a defense lawyer's help comes this judgment of Sharad Chand, which says that in case of circumstantial evidence, there has to be the complete chain. It should lead to only one hypothesis, that the accused is guilty. There should not be any flaw. So a defense lawyer is just supposed to break the chain. One circumstance you break, the whole prosecution theory, the castle that they build is going to come crashing down. One more problem that prosecution faces is that prosecution has to stand on its own legs. Defense can take benefit of the weakness in the prosecution case. Prosecution hardly gets the advantage of the weakness in the defense case. Though it is said that falsus in nuno is falsus in omnibus, this principle is not applicable in India, as has been held in Sayyid Ibrahim as well as earlier judgment Balka Singh, because Indian witnesses have to come and give color, give embroidery, varnish it, and then decorate it and then present it. So they say that it is the job of the court to separate grain from the chaff. But by asking same set of questions to these different witnesses, putting the bait after securing a one line of narration of events from one witness to another and getting the different answers, a defense counsel can take help of the principle, which is again narrated in Balka judgment, that if the grain and chaff are inextricably mixed up and it is not possible to separate grain from the chaff and completely a new story is getting churned out and there is an alternate hypothesis possible, a defense counsel is on. I would give the example of 2G case. There the main allegation, though I'll try not to be much anecdotal, but this example is important. There the case was that the licenses were to be distributed. So the minister's PA went to the one senior person and his 4 directors in the Ministry of Telecoms, and he told them that the license had to be distributed today itself, and the allegation was that this information had been leaked and the people knowing this would have only applied. So those 4 directors came to the witness box. I asked a series of questions that what time did you leave your house, what time did you reach the office, after reaching the office, when did you go, after how long did you go to the senior officer's room? And when I was asking this series of questions, there was a great objection from the prosecutor side and even from the court side that it is not a murder trial. Why such questions are being asked? Then I requested the court that, my lord, you would know when I do my final argument, just permit me to ask these few questions only. And then one important thing was, I asked Director A that when you entered the room, who all were present? He said that Senior, Mr. Senior, and other three were present. Then I asked Director B, who were present? He said Mr. Senior were present and other three were present. I asked C that who was present? He said Mr. Senior was present and the other three were present. I asked D. He said that Mr. Senior was present and other three was present. Because nobody wanted to be the first one to be the present in the room. So everyone comes forth. That means our argument, which was accepted by the court, that this theory of Raja's PA entering into the room after all these five gentlemen were sitting and then presenting a slip that the licenses are to be distributed today itself is incorrect. So, though now I do only generally scam cases, having the background of a chartered accountant, this thing is going to play even in the heinous crimes. It is going to play even in the scam cases or say financial crime cases. That they say that there is a particular meeting, there is a particular aspect, there is a particular approval of the file, there are particular oral instructions given, and A, B, C, D are present in the room. So, more the witnesses of the same event, happier the defense counsel should be. गवाह गिने नहीं तोले जाते हैं. So, more the number of witnesses, you will be able to point out the holes in the theory. More the number of witnesses, they are bound to contradict their own self. But recently, let me tell you a flip side also. In these coal scam cases which I do, the prosecution is trying to beat this technique, and they've come up with a strategy, excellent strategy, and especially by one Mr. Singh, that whenever he sees the hunger in my eyes that one witness of the same event has come and has deposed, and the way I'm gearing up for the second, and in case the examination in chief has not been recorded for all of them, he drops the witness. So now prosecution is also gearing up for this challenge, that they try and keep single witness for a particular event, but somehow I feel that would not help them in the long run, because illustration 114G of the Evidence Act would come in their way, that after having cited a witness, they are dropping the witness. So that means there has to be adverse inference drawn against them that the witness would have deposed contrary to their case. And in case a defense lawyer is extremely confident, he may choose to field that witness as his defense witness also. This judgment, Paramjit Singh, we must always remember. And I try to open my final arguments in every trial with that judgment, that the trial is not a fairy tale. Graver the offense, stricter is the proof. And because of the investigating officer's hunger to try and have more number of witnesses for a particular event, gives tool to the defense lawyer by getting more contradictions among them. For a financial transaction, the prosecution would bring the accountant, the finance manager, the finance head, some director, some MD, and believe me, all 4, 5 are going to create contradictions among themselves, and you will be benefited. Thank you.